Good evening, ladies and gentlemen. It is your friend, colleague, and perhaps mentor, HopLight. And you are back on the HopLight channel once more after a long hiatus. But you are here to see the HopLight Plan to Save America, Part 3, the Judicial Branch. Yes, okay. Look who it is. I've been gone for almost 4 months now. I apologize for that. I have moved myself to a new location somewhere within the interior of these United States. Yeah, I've been focused on that and couldn't pull myself away until now. And we are 2 days away from the next presidential election. And I just felt like I have to finish this series and get this out before that happens. Just compelled to do so. What do you think of the new studio? It's charming. It's cozy. Hope you enjoy it. But anyway, without further ado, let's get down to business. As I said, 2 days from now, we'll go through another presidential election. And I don't believe anything substantial, legally speaking, has changed since the prior election, 2020. So I'm expecting any and all kinds of shenanigans to take place. And if those shenanigans do take place, I am going to break off from this channel and form a secondary channel. As I've said in many videos prior to this, YouTube will pick up on your subject matter, and if you are covering things political in nature, anything that's not left of Mao Zedong will be throttled and suppressed and censored and hidden from anybody who wants to look for it, wants it in their suggested feed. Unless you're subscribed to the channel, you probably will never know it exists. And if you look at some of my videos, you can see like my Karl von Clausewitz a series on war has several thousands of views. Anything of this nature, Ukraine, Israel, yeah, it's like well under 100. I think it levels off around 80. So that's just the way things are. So if I'm going to have a political channel, I better just dedicate a channel to politics. And the HopLight channel will go back to more philosophical, deeper meaning topics, things that, well, honestly, should take up more of our time than politics, pop culture, and all that jazz. But anyway, let's wrap up this series with part 3 on the HopLight plan to save America, if it can be saved. Because I think, regardless of what happens on Tuesday, this country is now marching down a path that may spell the end of our democratic republic within our lifetimes. And certainly within the next 100 years, I think. I would put us on a timeline of 20 to 30 years where the democratic republic of this country, what constitutes its method of governance, will be essentially worth less than the paper it's printed on. But I hope I'm wrong. But how can we save this democratic republic in the meantime, while we have the ability and perhaps the will to do so? I've covered the executive branch, the legislative branch, and we will now end with a third, judicial branch. So number 1, and of course I'm referring to the Supreme Court of the United States when I refer to, the judicial branch, Article 3 of the Constitution. A 10-year term limit from confirmation. That means, just as I said with the second part, as it pertains to the legislative branch, when a justice or a judge is nominated to the Supreme Court and confirmed, that individual will have 10 years on the bench, SCOTUS bench, from the day of their confirmation and not a day longer. So without exception, when a particular justice will be confirmed and sent to the Supreme Court and the day they have to leave. We, for some reason, permit justices to serve lifetime terms on the court. And this is obviously codified in the Constitution. But I was always curious as to why this was. Didn't we wage a war and fight a revolution against a system where you would have a lifetime monarch as a ruler, as a sovereign? And isn't that concept 100% in opposition to our democratic republic form of government? People are elected, people win election, people lose election, they come and they go, they don't stay forever. And there are term limits for the president. And as I said in part 2, there should be term limits for Congress. But for the Supreme Court, once you're confirmed and you're on the bench, you're there until you die or you resign. I think some justices have stepped down and resigned their positions, but more often than not, they're usually there to the dead, which is bizarre. I never really got comfortable with that idea. And I think there's good reason, because we have evidence that some justices serve well past their prime. Some people might say we currently have a president who's about 30 to 40 years past his prime, but he's sitting in the White House right now until January 20th, 21st, and there's nothing we can do about it. So the leader of the free world right now is practically a vegetable. But there was a justice in the 1970s, I think, or 80s. I can't remember when he finally kicked the proverbial bucket, but his name was Justice Douglas. And he was judicial activist variety, left-leaning. But he was on the court so long that he essentially became senile to the point of complete incompetence. Not incompetence as in he's just stupid. The man, I believe, had to have his meals prepared for him and just daily tasks he needed full assistance with, because he was just old, senile, and just out of it. His law clerks took it upon themselves to write his opinions for him. And he would somehow get these opinions sent to his desk. He'd finish his tomato soup and then just sign off on them. So we had a lifetime appointed justice who was now, for all intents and purposes, an invalid. And his law clerks in his office took it upon themselves to write his opinions. Nobody elected these law clerks. Nobody voted for these law clerks. Nobody appointed these law clerks. But here they were, writing their opinions for this man, and he was just signing off on them. And that was that. That's a very good reason why people should not serve on the Supreme Court for longer than 10 years. I think 10 years is a nice, round number. Presidents serve 2 terms, 8 years. In my proposed second part of this series, congressional terms should also be restricted to 10 years for senators and congressmen. Justice Douglas being a good case for why. And even if you're not senile, and even if you're not a walking vegetable, what does a 75 or 80 or 85-year-old person know about modern American culture, modern American living? There's a reason we don't allow people older than 18 to vote, because you have no idea what's going on in the world. You think you do. You think you know best, but you don't know your butt from a hole in the ground until you're 18, bare minimum. And a lot of people would argue that you really don't know your butt from a hole in the ground until you're well into your 20s or even 30s. But 18 is the cutoff. That's nobody younger than 18 can vote, because you're not an adult. You know what's going on. So why do we permit people at the tail end of their life who have lived through all this history and can't possibly really know what's going on in the average 30-year-old or 40-year-old's life, and then they're just going to start, deciding what's best for the country? And so I would say, 10 years, and that's plenty of time. Point 2, open source finances. I don't think that anyone should have a problem with this either. Justices are given a salary, just like any other government employee. And we should know what other sources of income you have. And that should be open source, like on a blockchain or something where people can review their government employees that they're paying taxes for, and to see where their money comes from, if there's any additional money at all. If there's not, fine. They're living off their salary. Maybe they're writing books in the meantime, and they intend to sell those books later on after their 10-year term. Nothing wrong with that. But if people try to influence justices with gifts, with assets, with investments, and perhaps sway their vote, the 5 unelected lawyers out of 9 can literally move and change the shape of this nation. Andrew Jackson didn't really get on board with that idea. But yeah, for some reason, after Marbury versus Madison, people just kind of accepted the fact that the Supreme Court is the final arbiter of what is and what is not constitutional. Even though that's not written down in the Constitution, John Marshall said, yeah, we are. We're the most important branch. And I wrote an opinion about it, and you can read it. President Jackson didn't agree. And President Jackson got his way because he controlled the military. Number 3, executive override by a 2/3 triumvirate vote. So in my first episode for this series, I talked about how the presidency could be better managed with the distribution of powers of that office in a triumvirate. 3 men representing 3 different regions of the United States: West, Central, and East. And then one of those men would have executive authority as the commander-in-chief during times of war or conflict. And then that responsibility would rotate among the 3 the longer the conflict went on. And the 2/3 could vote to restore commander-in-chief to one of them over the other if they believe that the one out of the 3 was unfit for the task. Again, let's say he becomes incapacitated, or let's say he's a maniacal tyrant, and the other 2 members of the triumvirate see this and they say, yeah, it's no good to let him maintain that position. We're voting to take it back. So too, I would say in this third part that executive override of a Supreme Court decision could be achieved by a 2/3 triumvirate vote, which means that the executive votes at least 2 out of 3 to override a Supreme Court opinion. It would automatically trigger a mandatory 3/4 vote by the Congress to either uphold or invalidate the decision of the Supreme Court. So here's how it would play out. Supreme Court hears a case. Somebody brings a case, let's say, in the Eastern District in New York. And they say, yeah, we don't like it that people can express their opinions online. We believe that online speech is not covered on the First Amendment. Supreme Court says, we agree. Triumvirate says, that's nonsense. Of course it's covered. You can't really think of a worse decision to make at this time in U.S. history, when free speech is essentially, I'd say 90% exercised on the internet. No, people aren't printing out signs anymore and walking in their town square. They're going online and they're writing, or they're commenting, or they're making videos such as this. So triumvirate says, yeah, the First Amendment does cover internet speech. Now you have an executive branch saying, no, we don't agree with this opinion, and you have the SCOTUS that makes this new decision. It then automatically goes to the third branch of government, Congress. 3/4 of Congress must vote either to reinstate and validate the Supreme Court decision, thereby override the triumvirate, or they vote with the triumvirate executive and the Supreme Court decision is kiboshed. Caveat. A lot of times, members of Congress will vote present, or they'll abstain, or they just won't show up to do their job. In this scenario, every single member of Congress, if they wish to keep their position, must show up on the Hill and must cast a vote, yea or nay, on this issue. if it involves a Supreme Court decision and a triumvirate override, a veto, they have to vote yes or no. They have to take a stance. They can't just vote present. They can't abstain. They can't fail to show up. That is mandated. That's mandated. Okay, the people have a right to have finality in the law. And if this law is to pass, or if this law is to be changed by a Supreme Court opinion, then the Congress must get involved if there is challenge to it by the executive branch. Okay, and I think that one's way overdue, because in the history of the court, if you look back over the course of the last 75 years, the amount of judicial activism, as in judges reading things in the minutia of the law that were never really there, that a lot of people argue were never really meant to be there and could not possibly be read in that law, a lot of that has gone on. And we've just accepted it because, well, way back in the day, John Marshall on the court, Marbury versus Madison, said, we're the Supreme Court, we have this final say in what's constitutional, and you guys don't. This would override that. Number 4, and this dovetails off of the number 1 point, max age is 55 prior to nomination, which means you're out by 65. So, as I said before, if you're 75, if you're 80, if you're 85, I'm not saying you're stupid. I'm not saying you're incompetent. What I'm saying is the majority of Americans between the ages of 20 and 60 will be most affected by your opinions. You will probably not live to see the effects of your opinion on a case, whether it be good or evil, because you're just too far advanced in age. Therefore, you to pass decisions on a population that will have to endure your decision that you won't live to see should not come to pass. I just said it. I'm sorry. Sounds ageist of me, but there you go. 55, which means you're out by 65. You could be nominated at 50. You could be nominated at 45, but you must be nominated at the age of 55, no later. That's just the way it is. And last, a 2/3 vote by the executive triumvirate will create certiorari. Now, what is certiorari? When the court grants certiorari, a writ of certiorari, what they're saying is a challenge has been made in the lower court and it's gone one way or the other, and a party to that case doesn't like the decision and appeals to the Supreme Court for them to render an opinion. And you're not going to believe this, but the Supreme Court, well, I mean, maybe you will believe this because most of government doesn't do their job anymore, but the Supreme Court can agree can agree or disagree to not hear cases. As in, this case has gone all the way through the chain of lower courts, and the people still believe that there's a significant constitutional issue that hasn't been resolved and just wants ultimate decision from the Supreme Court on it, just so they can say it's gone through the entire judicial process. A lot of people appeal to the Supreme Court. A lot of people are shot down. That makes sense, right? It'd be foolish for 330 million people to have access to the Supreme Court just because they didn't like the way things went in their case. However, just because the court can grant a writ of certiorari or deny it doesn't mean they can do so indefinitely and fail to do their job. If the triumvirate knows of a case in the lower courts that's being appealed up and the court doesn't want to hear it because, well, it's kind of a hot button issue, it's awful political. Yeah, if I make a decision on that, half the country might hate me, and I'm a little gun shy about that. I don't think I want to make a decision on a case that has that kind of implications. The executive triumvirate with a 2/3 vote can compel the Supreme Court to hear a case and grant certiorari for them. In other words, if 2/3 of the triumvirate say that, yeah, you're not going to be able to dodge this one, the American people demand a final answer, at least from your branch, you're going to sit, all 9 of you, and you're going to hear this appeal to your court. We are hereby voting to grant certiorari on your behalf, and the court has to make a decision. And I think that's important too, because especially if you look in the history of the Supreme Court, there are some cases that a lot of people say should have gone to the decision of SCOTUS. And there are some people who say, well, it's kind of a gray area. I mean, they denied it because, well, they thought the venue was not proper, or it was an issue that had long been decided and it was just, redundant. But in cases where the court has avoided rendering decisions on particular issues, you could say some were strictly done out of political fears, as in they didn't want to touch an issue because they felt it was Congress's job to come up with a law to address, X, Y, Z. And that for them to step in and render an opinion on a case where there was very, let's say, scant evidence of legislative intent, the court saying, well, far be it for us to legislate from the bench. We just don't want to touch this. Whereas in many other circumstances, the judges and the justices have no hesitation in legislating from the bench when it pertains to matters such as A, B, and C. But for matters X, Y, and Z, yeah, we don't want to touch that. The executive could now step in and tell the court, guess what? We're telling you, you have to. This essentially holds more of the branches accountable to each other, and that the branches cannot skirt their duties simply because, well, they have this privilege or they have that privilege, or there's this loophole that allows them to avoid having to take a controversial step and possibly, put themselves in a poor light if they, choose wrongly. The executive would, under this plan, have that ability to enforce certiorari on the court. Okay, that's it. That's going to be the shortest one, I think, because let's face it, the judicial branch, as intended by the founders, should have been the weakest branch of all three, but somehow through legal machinations and I would call it like asserting itself, has basically been the most important branch, historically speaking, since at least 1795, 1800, whenever Marbury versus Madison was official in the record. I think that was maybe 1800, 1803, roundabouts, over 200 years. So basically since the beginning. And I think that needs to change if this republic is going to be saved. We can no longer just, look at the Supreme Court as the end-all, be-all, the sages, the all-wise, the all-knowing people. They're human beings just like you and I. They have political tendencies. They're subject to the 7 deadly sins just as much as you and I. And for us to pretend as though they're superhuman and rise above all that is foolish. And I think if this country is going to be saved, the Supreme Court, through these measures, these 5, it's a good start. And perhaps there's room for extra, but I think these 5 put us in a much better place. Okay, that's it. Hope you had a happy Halloween. That was about 3 days ago as well. The election, yeah. Whatever happens, I do encourage you to vote, to exercise your right, assuming it still matters. But yeah, I will announce the official second channel in the days after. And it's definitely going to be more subjective. It's going to be more opinionated about what I think needs to happen for the United States of America going forward, and what we can possibly do to salvage what we have left of a country. Because I do believe that we are at a crossroads coming up here where things are going to go sideways in a very bad way if drastic measures aren't taken. And I hate to make it sound that dire. I hate to make it sound that serious, but it truly is. In my lifetime, we had a former president who's running currently, who had a major attempt on his life and a second attempt that probably would have been just as horrific had Secret Service agents not seen it beforehand being set up. I'm speaking in regards to the one at the golf course. A lot has happened in the last couple months. I apologize. I wish I could have covered these as they occurred. But yeah, these are the times we're living in, and there are no coincidences in politics. As FDR, I think it was FDR once said, if you see something happen in the political world and it looks coincidental, understand that there is far too much at stake in the political world for something to be a coincidence. If you saw something happen, it was meant to happen for a reason. And I always keep that in mind when I see these things happen in the political world. Joe Biden deciding to step down after a complete calamity of a second debate, yeah, that was no coincidence either. It wasn't just a good time for him to step down. I believe he was told, you need to step down. And here we are. We have Donald Trump and Kamala Harris vying for the next 4 years to be the President of the United States. And we'll just see how it goes. In any event, I hope you have been well. I have been well, and we will see you here next time on the HopLight channel. Till then, take it easy.